hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness.
All right, so welcome back to the next episode of Just Law. I'm here with my co-host Leah Silverman, and we're very fortunate today to have on both Professors McMorrow and Professor Hashimoto, both professors at BC Law, to talk about COVID-19 and just a lot of the really novel legal issues that are kind of arising out of everything that's been going on for the last year. And I mean, just recently, within the last few days, we've hit the 1 year anniversary, and so we're just going to kind of take a look at really all the issues of which there are many, and some of the legal dimensions of a lot of these, a lot of what's been going on in terms of liability and insurance and just all the sort of issues that have kind of arisen that the courts are dealing with and have had to relatively recently deal with and trying to navigate our way out of the pandemic. So Professor Hashimoto, he focuses on the interface of law, science, and medicine, especially in the areas of healthcare policy and the role of scientific evidence in the courtroom. Educated as both an attorney and physician, he teaches torts, environmental litigation, healthcare law, and evidence. Professor McMorrow, my current torts professor, currently serves as the Associate Dean of Experiential Learning and Global Engagement at BC Law. She teaches torts, professional responsibility in the law school's semester in practice externship program, and her scholarship is primarily in the area of professional responsibility and legal ethics. Professors, thanks to both of you for coming on today.
Yes,
Great
thank you so much. I'd also like to point out Professor McMorrow was my torts professor as well, so it's nice to see her here 2 years later. But Professor McMorrow and Professor Hashimoto, do you want to kind of introduce yourself to our audience and talk about your work and your experience in this area?
Well, so as first of all, great to see my tort students here engaged so deeply in these issues. As Associate Dean for Experiential Learning, last summer, when we began to see the fallout from COVID, we began to see our students not having experiences, and we knew that there was a rise in the needs of low-income clients. Our clinics at BC Law created the COVID Relief Legal Services. Leah was involved in that. Thank you so much. We would end up having 47 students working 20 to 40 hours a week, doing a range of projects. Some of them were direct client services, helping in teams of two with the PAIR, Political Asylum, Immigration Representation Project, folks who were detained in detention, trying to get them out on habeas. We had a team of 8 students working on advising individuals how to navigate unemployment. That was under the supervision of Professor Manuskin and Professor Rivera from the clinics. We had a small group working on debt issues, and they would do community education. We had some doing prison discipline just because there was a need for that work. Then a lot of research with outside groups, and often dealing with the pressure that COVID was putting on a lot of groups, like environmental groups. They could see ahead that the tremendous social expense of dealing with COVID could have a serious negative impact on some of the environmental priorities that they were trying to pursue. So the ripple effect of COVID was just profound, and we could see that even just scratching the surface as we created COVID Relief Legal Services. Now, that's not about lawsuits about COVID so much as it is about the legal fallout and the impact of COVID is having on all sectors of society, and therefore all sectors of legal services.
Yeah, well, I think that's very important to recognize. I was part of that clinic this past summer, and I worked with one of the environmental groups, and something that they saw was the lack of support we worked with water and different water systems and water infrastructure, and how that was kind of put on the back burner because COVID was such a present issue, but people were still not getting clean water at prices that they could afford. So it was definitely a very interesting experience.
Right.
And Professor Hashimoto, do you want to talk about your experience in the area?
Sure. I'm coming at it from a couple of different perspectives. From a legal perspective, I'm very interested in looking at it from a tort liability and scientific evidence perspective. I'm also a physician, and my medical specialty is occupational and environmental medicine, which looks at the impact of environments, especially workplaces on health. And I've been very interested in issues involving public health more generally. So my work is empirical in the sense, especially of looking at organizational policies and their impact on health in workplaces. And in particular, my interest is in the healthcare workplace. And I'm responsible for the workers, the employees at the Mass General Brigham system, which has, at this point, some 80,000 employees, and the impact of COVID and COVID-related policies, on their workplace health.
Excellent. Well, it's really great to have you both on, and I guess where we could start is sort of an area which you both alluded to, and it's I think something both of you could speak to, and it's really sort of the genesis of the idea for doing this episode was something I was sort of thinking about in the last few weeks was the tort issue, negligence, the spread of COVID, mask wearing. What happens when somebody sues somebody for allegedly giving them COVID? Maybe their mask wasn't on tight enough, and just really the standard of evidence that courts will use in these cases when it comes to COVID and COVID issues, and really trying to litigate something that's invisible and microscopic, and something that the legal system, at least perhaps not since the early 1900s, since the last pandemic, has had to deal with. And I know we're a year into this now. So I guess what are really the issues, the novel issues that courts are grappling with in these types of cases?
Dean, do you want to go first, or should I?
Why don't you go first and I'll go second? I think that's a good natural order.
Okay, so I'm not sure about that, but I just step back and recognize that the early lawsuits on COVID were not tort related. Like probably 20% of all the lawsuits in 2020, according to an ABA survey, were actually the single biggest issue addressed were contract issues of businesses trying to seek business interruption insurance. There are a lot of related employment issues about family medical leave and intersection of workers' comp. So I think the expectation initially was, we're going to be overrun by these tort suits. So point one is there's not as many tort suits being brought, and not as many successfully brought as might have been anticipated. And probably because of some of the barriers that we can immediately recognize. And one of the big barriers is that for those of you who've taken torts for like a negligence action, you have to have a breach of a duty that causes damage. And one category, the causation issues are incredibly complicated in a typical case. Like now they're not as they're probably easier to address in very confined environments. So there are have been some lawsuits by cruise ships and by nursing homes. You can envision those are enclosed environments which control who comes in and out, but still involve some movement of people in and out. So we have those, but the casual environments, lawsuits involving restaurants and others locations, you haven't seen a significant negligence claims claiming that there was a spread of COVID. That's something that defendant did cause COVID, in part because COVID, proving causation, how do I know I got it there versus any other place? And that's where really it turned it over to deans, even in controlled environments like nursing homes. Let's assume we can, and cruise ships, assume we can prove breach of duty, which is that's a generous assumption right now, because they have to act like the reasonable, prudent person in the same or similar circumstance based on the info they had in that moment, and what they knew or should have known back in, say, February, March, April, in a fast-moving environment of information. So let's assume breach of duty, that the causation, I would predict, even in those tight environments, and let's assume somebody got COVID and a nursing home passed away, then there's a general sense is there's going to be a lot of complex expert witness testimony, and that really is Dean's expertise.
Well, I agree with Judy that, as you'll find more generally, tort law is a very poor public health tool.
Yeah.
And certainly, because of breach of duty issues as well as causality issues, it's generally pretty hard, to establish that a defendant has breached a duty or has a duty at all. and that there is proximate cause as well as but-for cause. There are certain circumstances, however, that it does come up, as Professor McMorrow points out. Households is an example of where the risk is so high. If you have a member who's infected in your household, the risk is very high, as is true on cruise ships and nursing homes. Where we are seeing some lawsuits is in the area of workers' compensation. That is, we have the first major tort reform and the most lasting tort reform has been workers' compensation, where states have set up, their own tort systems in which there is no requirement of showing duty or breach of duty. There still is the requirement of showing causation, however, and so that does remain, that can remain an important issue. The point being is that when we think of causality with respect to COVID, it's really best looked at from an epidemiological public health perspective, which is based upon degree of risk, which does not translate very well in terms of but-for cause or proximate cause, because in terms of exposure, any exposure, unless it's a rather unusual circumstance, again, it's hard to meet that more likely than not requirement. I suspect that there'll be very little outside of workers' comp, very little successful litigation, except in the because of these problems. What's interesting, as Professor McMorrow points out, is that the better public health approaches to this problem really are built in contract law. And so, for example, at the Mass General Brigham, this healthcare system that I work in, we developed in the early going what we call COVID pay, where any employee who develops a COVID infection is entitled to pay as long as they appropriately test and they stay out of work appropriately. And this contractual approach has been very successful in terms of making employees feel that they're protected and supported. What's also interesting is the lack of worker comp suits as a result of that. In an employee population of 80,000, we have 8 worker comp claims that are presently being considered. In contrast to the state, the Massachusetts state, which has over 5,000 worker comp claims within healthcare systems. The Yale Medical Center, for example, has 6,000 worker comp claims. And so by relying upon contract law, employment law, and basically giving workers the benefit of a doubt and encouraging them to stay out of work, which is in the interest of the hospital if they're infected, it was sort of a way of creating a private system that helps to compensate and avoids tort liability.
That's a really interesting, Dean, and one can envision interesting policy discussions like nursing homes, where you have generally low-wage workers who, if they do get COVID and have to stay out for 2 weeks and then simply don't get paid, it's such a burden on their family, and that it causes people structural incentives to not get tested or just muddle through. And is one of the questions is, say, Mass General did it through private agreement with their employees, but the question is we're nowhere near able to think about it now, but might we eventually be having policies that apply throughout workplaces in settings like this, to say every workplace of a certain size ought to have policies like this?
That's right, or especially those workplaces in which there is a vulnerability, and there's a public health need to get tested and stay out of work. Those workers who are working remotely, you could argue, don't need to have that kind of incentive, because there's not the same sort of public health concern. But I agree that this sort of private contractual approach could have larger implications.
And if we could just return to the tort issue for a second, I know you've said that, I think we've heard both that these types of cases are not particularly prevalent thus far, and it's also sort of a poor tool to try to kind of manage the issue. But I guess the question is what kind, let's say, because these cases are somewhat inevitable. I mean, we've had all kinds of reports in the news of, parties and in places where people are, through contact tracing and otherwise, you find that not everybody follows all of the rules. And we do know for a fact that if you're not wearing masks and you're not social distancing and you're not doing what you're supposed to, you will spread COVID. So like, let's say a court had a case like this, in front of it where somebody, I don't know, is a roommate or lives in an apartment building or, somehow is exposed to COVID in a way that had people been following, but for, as we might say, people not following the law or the, sort of the healthcare guidance that's out there, that wouldn't have happened. So what kind of standard of evidence would a court look at? Should it take up a case like this and trying to figure out, risk and liability and negligence and exactly how you figure out the causation for something you can't even see?
Maybe I should speak to that because it involves contact tracing, which is an area that I'm very familiar with, both sort of in public as well as sort of within hospital systems. Public, contact tracing is this tracing, which basically it's a rather rigid public health system, which is based upon CDC criteria, in which, in order to find an issue in terms of exposure, you need to be exposed for a minimum of 15 minutes with face-to-face exposure. Within hospital systems, which have surgical masks, which are much more effective than cloth masks in the public, it involves showing that there is a breach of this personal protective equipment, including masking. In the public, there isn't such a requirement just because the mask quality is not as high as in the hospital. The difficulty of depending upon exposure tracing is that it is focused on identifying only one factor. It doesn't focus on identifying other risk factors. And in particular, household exposures. That is, the risk that is increased because a member of your household is infected is so much higher than any positive exposure tracings that, public health experts would agree that, that would be, the more likely cause, no matter what the exposure tracing results are. Assuming that there is no household exposure, you've only identified one facet of exposure. Let's say, contact tracing based on the fact that you sat next to someone in a restaurant. It focuses only on that exposure and doesn't focus on exposures outside of that. And so that's the limit of that scientific evidence, is its very narrow focus. I'm very familiar with this just because we face the same problem within hospitals and exposure tracing within hospitals, which is much more intense, much more exacting, but it's only able to identify a relative handful of possibilities. Again, it's not definite because one does not effectively rule out other exposure causes. And so again, that is the problem, is sort of the lack of having comprehensive information and being able to assess total risk rather than simply focusing on the positive result that you have from a single contact tracing.
And so, Dean, like in terms of if there were ever litigation, let's identify the huge barriers to litigation and say a context like this, that somebody went, to parties and refused to wear their mask, was indifferent, and first you have to have somebody who actually gets sick, right? You need damages, unless you're trying to do an intentional or reckless infliction of emotional distress, which has its own hurdles. But somebody gets sick, and the damages first have to be high enough that a lawyer would actually take it. And then the next piece is that you have to have a defendant who actually has money available to compensate if you want, for the vast majority of these suits to go forward. So like most of those college students are just essentially judgment proof, no matter how egregious their conduct. It's probably not going to be, we're not going to see a lot of lawsuits by that because lawyers will screen them out for economic reasons. So let's assume you get through that.
That's absolutely correct. Yeah.
What's that? Yeah.
Just on those two issues, Judy, we know that in 40 to 50% of cases, the infection is, the people who are infected are asymptomatic. They're totally without symptoms. Mm-hmm. And so it would be hard to show damages. Mm-hmm. And on the second issue, we know that the other large risk factor besides household exposure involves low-wage communities. And so if you live in Brockton, if you live in in towns in which wages are low, the chances are high that it's from that general community exposure rather than any individual exposure identified by contact tracing.
So if Dean talks about the sort of epidemiological or the medical approach, I think if it ever got through the initial hurdles and you actually got into a lawsuit, that while the contact tracing can only focus on a single factor, if I were a defendant, a lawyer for the defendant, I would then be doing all this discovery and take a deposition of our plaintiff here and identify all the other things that plaintiff had done and all the other places where they'd gone, and not only where they'd gone, where people in their household had gone, or if we don't have household, others. And if you don't have household, all it tells us if we don't have known household. It'd be the defendant's job to develop all those other risk factors, which is going to then truly muddy the water on the cause and fact.
Great. I had another question just going off of something Professor McMorrow said. I think it's something that you're sort of familiar with from a lot of our conversations, and it's been really, I think, one of the most sort of heart-rending aspects of this whole pandemic has been what's going on in nursing homes. I mean, I know we're all familiar with what's going on in New York State, but really across the country and around the world. You have an environment where we have the most vulnerable patients, most vulnerable sort of aspects of our population. At the same time, you have folks living in close quarters, indoor. I mean, just all of the ingredients for having a serious issue. I mean, you have not only the health factors as I alluded to, and I'm sure there's much more there, but you have at the same time especially earlier on in the pandemic, from a legal and policy perspective, I mean, it's kind of been the Wild West in some of these places. I mean, I have relatives of mine who are older, who in some of these nursing homes, and in terms of figuring out what's the guidance, what's the regulation, what are we supposed to do, what's the standard of care, how distant can you be? We don't have, it's just been chaos. It's been awful. And so I was just wondering if either of you could sort of speak to the environment, both I guess in Professor Hashimoto's case from a healthcare perspective in the nursing homes, but also legally in terms of policy and healthcare authorities. Like we saw a year ago right now. I mean, what was going on in some of these places was just absolutely devastating. And so if you could just speak to that dimension of the problem in particular.
Yeah, no, I'd be happy to talk about that. I think that is one instance where where there will be some litigation, consistent with what Professor McMorrow said earlier in terms of a sort of a distinct identifiable source. Although there will still be the issue of deep pockets and the issue of external exposures in terms of risk. A difficulty with nursing homes during the COVID pandemic is the constantly changing standards of care. It's hard for us to remember, but if you go back to a year ago, we didn't understand this coronavirus very well. And it didn't become apparent until various points in time that various interventions would be helpful. And so it even took a while, for example, to establish the CDC standards around social distancing, the standard of requiring universal masking of both workers as well as patients, and then the additional standard in terms of doing medical surveillance on a weekly basis if there are any clusters. And so the constantly changing standards of care, have placed a heavy burden on nursing homes. I have to say, at least within what I've seen in this state, the state of Massachusetts, that although initially there was a large problem because nursing home environments are in fact ideal for the coronavirus in terms of the lack of distancing requirements as well as the lack of masking, the problem was very quickly handled through state orders. And so there might be some initial liability with the debate over what were the standards of care. But in terms of the success of the state of regulating this particular environment through state orders is impressive. Again, by imposing regulations consistent with this evolving standard of care.
It's interesting that you talk about the changing policies in the beginning, because I was home with my family in New York for the first few months, and the mask mandate was weeks ahead of here. And I came back to Boston to take my finals and be kind of alone in my apartment. Not that my family wasn't wonderful, just a bit distracting. And there was no mask mandate yet. And it was crazy to me coming from New York to going here and seeing people just walking around, their face free. It really, as things change, the public perception also changes as to what is that reasonable person standard.
Exactly. You know, the CDC standards, along with the state orders, even though you have sort of this national guidance with CDC, they were basically sort of enforced through state orders. And so different states did different things, especially with things like masking. And unfortunately, things like masking, public masking, have really sort of turned into politics, which is the worst possible thing for a public health measure to do. But that is one of the unfortunate things that has happened during this pandemic, is that key public health measures, masks and now vaccinations, have become these very hot political issues, you know, which is at odds with the idea that in public health, you basically need to have universal enforcement.
Yeah. One other question I had, just going back to an earlier point about, you know, COVID in the workplace and sort of occupational health, and trying to, you know, keep people who you know are not able to work remotely safe, is one thing. And this is really more public facing as much as anything. Is, you know, you see a lot of businesses, particularly you know, dentists and estheticians and other places where, you know, that type of work is being performed. Where, I mean, I know myself, and I'm sure everybody else, you know, a lot of times you'll see you know, yourself being required to fill out a form basically saying, hey, if I get COVID, it's not on us. You know, I'm essentially agreeing that if I come to this business that you know, I'm willing to take on the risk. What are the legal implications of agreements like that? Because you see these, I mean, everywhere I go now, they're kind of like these haphazard, like 3-sentence, just sign your life away, you know, if you get it, it's not our fault, things that you're seeing almost everywhere now, it seems that I go. I mean, what is, I guess, like, you know, if let's say a case were to be brought on an agreement like that, like what are the types of issues that could turn on? And again, I know earlier we spoke about, you know, contract, breach of contract, and, you know, contract being a better source of law than torts to kind of deal with that. So, like, let's say the contract issue were tried, what might happen?
So, so Tom, since we are in about 2 weeks, we're going to be addressing that question in our torts class. Lea knows the general broad contours of it, which is they're attempting to provide evidence for what's called express assumption of risk. You're right. By contract, to waive any claim for negligence. So it will be those agreements. And again, we have to assume all those other preconditions are met, that somebody gets sick, that it's bad enough that's worth bringing a lawsuit. All the reasons why we probably aren't seeing a lot of lawsuits. But let's assume one comes, then it would turn on just pretty standard legal protocol. Was it clear? Was it expressed? Did it waive any claim of negligence? Because many times these kinds of agreements are designed to make it easier for the defendant to get summary judgment. And generally what they want to say is, you are assuming the risk of our negligence in how we operate our restaurant or our aesthetics or our nail salon or the like. And some places are not asking for them because I think they're probably either they're not thinking of it, or their insurer is saying, these cases are not getting traction right now. Because if somebody's willing to go to a nail salon or aesthetics or a bar, chances are they're willing to go to a whole lot of other places. And so they're exposing themselves out in the world. And even without an express contractual assumption of risk, a recognition that they are their own conduct is going to defeat causation. So, Dean, what's your sense?
Yeah, no, that's absolutely right. Essentially, what courts need to decide is, was this a voluntary agreement, or did this involve, what is called a contract of adhesion? So there are certain places, where you go for recreational, other voluntary reasons. And as you'll read, in your tort textbook, however, that there are certain environments in which courts would agree it's a contract of adhesion. A classic example would be hospitals. If you break your leg and you go to a hospital, can you waive your right to sue in tort liability? And the answer, is no.
Interesting, very interesting. So I just had a few questions left. One thing that I just added this thing is it just happened very recently. So President Biden announced that he's in essence instructing, ordering. There's been a variety of verbs that have been used to describe this. The states by May 1st to make all folks eligible for the vaccine. And so I know this is maybe more of a situation in constitutional law than sort of other areas of the law, but I'm just curious. You've seen from the Trump administration to Biden and just sort of the various levels of the government and agencies that have kind of grappled with this in terms of the vaccine rollout. And I was fortunate enough to I'm actually on Tuesday getting my second vaccine. I know I think some of us here may have gotten it already, but for most folks it's still something that's a ways off on the horizon. But I guess President Biden instructing states to make everyone eligible to get. I mean, this is something where you've got you feel free to correct me if I'm wrong, but you've got the vaccine coming from Pfizer and Moderna and these other life sciences companies that goes to the federal government. The federal government distributes the vaccine to the states, and they can only give them out to the extent that they have available vaccines to give. But the president basically telling the states, you're going to make everyone eligible by May 1st. Does the president have the authority to do that? Or are there like a abundance of vaccines? And Professor Hashimoto, you might know more about this, but I don't know. Are they that available that we can do that? Is that an actual legal thing that the president can do? Or I guess what does that mean for folks?
Yeah, I mean, this is an example again where there has been a tension between federal authority and state authority. And so currently right now, you have the federal government, including the CDC, as well as through the president, sort of advising states on what they think, what groups they think should be prioritized. And so there was a pretty good consensus between the federal government and among states that in the first wave of vaccinations, healthcare workers would be prioritized. But since then, there has been disagreements developing on, what group should be prioritized. I mean, the latest controversy involves, of course, elementary school teachers, with some states prioritizing them, other states not. It's been certainly an issue of contention in our state. What President Biden is doing, by making this federal declaration, by saying, on May 1, there's going to be enough vaccine provided through the distribution by the federal government, that now the federal government, in terms of health and human services, is going to order states to move away from any kind of categorization based on priority. Now anyone, should be able to make an appointment and get vaccinated. He's doing that because, yes, it does appear that there is going to be sufficient available vaccine by the end of May. But there will be a legal controversy that will undoubtedly be litigated in terms of a suit against HHS by some states, as to whether the federal government, through executive order, can require states in this regard, because this is really the first time that the president is stepping up. In the prior administration, there was enormous deference to states and allowing this basically to be done through state orders. So this is the controversy, and it will be interesting, to see how that turns out in terms of the litigation. I have to say that this case is likely to go all the way to the U.S. Supreme Court. I think that there are good arguments by other side. It basically goes to, what is within the intrinsic power of the federal government on an issue in which there is not a federal statute, and you're trying to do it basically through executive order. I would suspect that the Supreme Court, being composed as it is by conservatives, that this is going to be a very close call. Some of you may be aware of the case that was decided last fall that involved a public health decree by California, a case called South Bay United Pentecostal Church v. Newsom. And in that case, it involved a state order, and whether a state order it was constitutional because it placed density limits on churches. And for the first time, that there was a majority that struck down this public health order. Now, that was a state order, but I think it did demonstrate the point that that a majority of justices are willing to look into this area of public health and make a decision that is contrary to the judgment of public health experts and base it on sort of traditional reasons. In that case, it was the right of religion. In this case, in this instance that we're talking about sort of federal-state relationships. So it'll be very interesting to see how the Supreme Court decides this issue.
Very interesting. Yeah, when I saw, the president's remarks the other night, on that, May 1st, everyone can be eligible. I was thinking I have to ask that because, can the president do that? How might this be decided? And I guess, I guess we'll have to wait and see. I did have just two last questions, and Lea, if you have any other questions you'd like to ask, just as we try to wrap up. I guess kind of looking to the future as the weather warms up. I guess not today, it's like 16 today, but we're getting there slowly but surely. And we turn our attention to spring and summer, and we try to get case numbers down and vaccinations up, and we try to kind of turn past this most troublesome chapter in our history. Looking ahead, people are already talking about Bill Gates has been very outspoken on the issue of pandemics and public health, along with a lot of other folks. It's talking about could there be another pandemic? And I'm just curious, what type of legal or policy changes or changes within the federal government or sort of the healthcare system might we see going forward to try to prevent a situation like this? Because I know a year ago right now, March of 2020, it was just absolute chaos. I mean, I don't think healthcare system, the governments, none of our systems were prepared to deal with this. And so I'm just curious, from a legal perspective, a policy perspective, any perspective you want to look at this from, what kind of changes might be on the horizon to try to be more prepared in the future for God forbid there's something like this.
Well, this is definitely Professor Hashimoto's bullseye, but one can already see that the FEMA, federal policy, any rational federal policymaker is going to learn from this. It's been an incredible experiment. It's been a lot of learning about what to do and what not to do. And so both the policymakers, the health, the world, they're all going to be looking and identifying, if not best practice, better practices looking ahead, because nobody wants to repeat this. And Professor Hashimoto, you probably have even more specifics there.
I think this, I think this is, the key issue. I will have to say at the outset that I'm not convinced that this pandemic is anywhere near over, that, we're dealing with a highly infectious virus. It's very true that in past pandemics, they generally have come in a couple of waves and then disappeared for mysterious reasons. And that may occur here, although I think the more likely possibility is going to be that this coronavirus will become what we call endemic, that it, like other forms of the flu, it may stick around. It may be hard to stomp out. If you think about it, this is an international problem, and you're going to need to stomp it out internationally, not just within our country. I suspect that this is so highly infectious that it will be endemic, very much like the flu. And it will not be surprising if every once in a while we will need to get vaccinations, if not on a yearly basis. And the legal issue will be, at some point in time, will we want to make vaccinations mandatory, for example, in order to stomp out this pandemic? But in looking forward to future pandemics, I think that's exactly right. I think, there's some thinking in the public health community that, with climate change, with the fact that the 20th century, with its relative lack of pandemics, was really an anomaly. That if you go back 19th century and earlier, there were regular plagues, there were regular pandemics passing through. And so what we've begun to experience might be only the beginning in the 21st century. The big issue is over governance and structure. And we've touched on those issues in the sense of, what is the role of the federal government? Understanding that the traditional public health infrastructure, which has eroded terribly, in the latter half of the 20th century, was built around local control. So you have, for example, a Boston Public Health Commission. You have public health being administered locally through towns. That is the traditional structure. That structure has collapsed in this pandemic, with the latest example being vaccinations, in which basically we gave up on relying upon these very local structures. So it will be very interesting in terms of, what is the future? I suspect a much larger federal role. There will be, this also showed the importance of a state role, but, the potential conflict between, what is the role of the state vis-a-vis the federal government.
Very, very interesting. A lot of big stuff, a lot of big things to think about here. And, again, I think, it'll be interesting to see, through the end of this year, what happens. I mean, hopefully, we can have conversations like this in person in the not too distant future. I think that'll do it for us. Lea, do you want the last word, or you think that's a wrap?
I just have kind of one more point on the federal government. I think that I remember from my research in the early pandemic that there was in the Obama administration a pandemic kind of preparedness, I don't want to say unit, but maybe office after the Ebola epidemic. And I know that was shut down by the Trump administration. So I just hope that this becomes something that we see as a necessity in the federal government, this preparedness going forward. And that is my last thought.
Well, there you go. You heard it here first. All right. Well, Professors McMorrow, Professor Hashimoto, thank you so much for coming on today. It's been a great discussion. We've done, I think, this might be our 8th episode since starting this last fall. This might be the best one yet. This was really insightful stuff. So thank you so much again to both of you for coming on. I'm Tom Blakely. I'm your host here with my co-host Lea Silverman. Again, those Professors McMorrow and Professor Hashimoto of BC Law, talking to you about COVID-19. And again, thank you very much for tuning in, and we'll catch you next time.